56, 59, 73, 74, 76, 78, and 79 of the Finance Bill 2023, because from my reading, I find that it is they threaten to violate the Constitution if they become law. So I've moved the court in a preemptive manner, which is allowed under the Constitution, because the Constitution allows us to litigate against threats. So I perceive this to be cascading threats against the constitutional order of this country, and I've moved ahead to invoke that power that I have as a citizen and a member of the public, and also that the courts have, to be able to hear me and to make a determination. So basically, the power to impose tax is not absolute. It's a donated power by the people of Kenya, and the organ that is mandated to impose tax is Parliament. That's why you hear, when you look at Article 210, you'll find that they say taxation has to be as provided in legislation. So the executive is supposed to propose. But what is happening right now is that the power to tax has gone to the executive. They are like talking in a manner that they are not proposing or requesting. They are talking that whether you like it or not, you'll have to do ABCD. So that power does not reside with the president or the cabinet. It resides in Parliament. But unfortunately, because of the behavior of the majority side in Parliament, which has gone into bed with the executive, and you can hardly see a distinction, you'll find that Parliament has lost its autonomy. Parliament has become a small appendix of the executive, and Parliament does what the executive wants, because the majority side is part of the executive. And that being so, we are left with no recourse but to go to the courts or to the streets to try and uphold the Constitution of Kenya. So among the bills, among the proposals that I'm challenging, we have the one that has been popularly fought, which is on the housing, and that is Section 76 of the bill. I've challenged it for being unconstitutional, for threatening property rights, for threatening constitutional provisions that protect the salaries of independent office holders like judges, like the Auditor General, like the Controller of Budget, and the commissioners of the members of in the constitutional commissions, where it is clearly stipulated that you cannot touch their salaries. But this particular provision is going out to touch those salaries. So if you look at the property rights, there is no justification for taking money from one person and putting it in a pool and turning it into a lottery. A person has got the right to invest their money or to use their property the way they choose, as long as they don't violate the law. And that is very clearly stated in Article 40. The same Article 40 prohibits Parliament from making any law that arbitrarily takes away the rights of the people. So that's about what I can say about that particular provision. There are many issues. The other section that I'm challenging is Section 52, which also threatens property rights by giving the Commissioner General of KRA the powers to go and attach people's properties without even notifying them, just on the basis that he thinks that they have not paid taxes. That is not acceptable under the law. We have due process in this country, and it must be protected. You have Article 56. You also threaten the Bill of Rights to property, whereby the Commission again have the power, if you overpay tax, the Commissioner will hold on to your money that you overpaid and says we shall use it to pay for future taxes. So that's not how it's supposed to be. The ideal thing is to refund the person his money and let him use it the way he wants, and when the time is due, he pays. And when they are retaining this money, they are not giving it any interest. So to me, that's an arbitrary deprivation of property which violates Article 40. You have Section 59 of the bill, which prevents somebody who has complained to the tribunal about a tax claim that you cannot amend your plea. You cannot amend your plea. Once you go to that court, you cannot adduce new evidence. You cannot amend your plea. That totally is unacceptable. That curtails the right to a fair hearing. A person should be able to amend their plea. A litigant should be able to amend their plea depending on the circumstances of the case. So you will also look at Article 36, which also threatens access to justice, where it proposes that if you are dissatisfied with the decision of the tribunal, for you to appeal, you have to pay 20% of the disputed tax amount. That is going to cripple many businesses. And then you see you are not even depositing this money with a court. You are depositing it with the tax collector. And you know this tax collector hardly refunds money. So there is no guarantee that your money will be refunded. The money is not earning interest. It becomes very expensive to litigate. And so at the end of the day, you find that it may not be viable even to go to court. So people are going to be destroyed by the taxes. The KRA alleges you owe them. And you know, in this country whereby sometimes taxation is politicized, you can be hammered with a claim that is unreasonable. So you need the protection of the court. And there's no way you can be denied the protection of the courts, from the tribunals to the Supreme Court, where you feel your rights are being violated. So we also have Section 30 of the bill, which introduces where it says that if you lose goods that you have paid taxes on and you are being compensated, they are subjected to VAT. A totally difficult reasoning to understand. It also violates the right to property. You also find that the Section 28 of the bill, which imposes VAT on petroleum products, the impact is just basically somebody is trying to remove the industrial base of this country. People are going to be businesses are going to move out. The country is going to be very expensive and unproductive. Businesses are going to move out, and that threatens the right to socioeconomic rights in Article 43. So these are threats that are discernible and are available. You look at Section 33 of the tax, which reclassifies agricultural inputs into agriculture from zero VAT to exempt, and that is going to raise the cost of doing business. The farmers, now if farmers can't produce, and you see a big part of the country are peasants, you want to get these peasants onto the street because they can't produce. They produce, they feed themselves, they don't disturb anybody else. Now you are going to make sure that these peasants are unable to produce and are going to end up on the streets. So you cannot allow those kind of things to happen. Section 78 and 79 of the bill proposes to amend the Statutory Instruments Act to remove the staged repealing or sunsetting of statutory instruments. We know very well that statutory instruments are regulations or bylaws that are made by the executive or the power donated by Parliament. The Parliament does not cede it the responsibility to ensure that the laws serve the people. So there has been an automatic mechanism whereby if a regulation is made, then when it turns 10 years old, it dies and a new regulation has to be made or it has to be revised or something. That ensures Parliament keeps on supervising laws made by the executive. Now removing that is really creating a dictatorship whereby the executive, whatever the executive will have passed, there will be no mechanism of reviewing or removing these laws, and some of them can be very, very oppressive. So when you look at that, we have also looked at Section 73, 74, 76, 78, and 79 of the bill, which propose for the National Assembly to unilaterally make amendments to laws that were passed by both the National Assembly and the Senate. Now that is totally unacceptable because these laws that were done by the two houses concern matters affecting counties. So one house cannot be allowed to amend those laws alone. And you know, under the bad practice we have in this country, the finance bill does not go to the Senate, Therefore, the National Assembly will deal with it alone. So I'm saying that you cannot amend the Betting, Gaming and Lotteries Act unilaterally through the National Assembly. You cannot amend, that's Section 73. Section 74 proposes to amend the Kenya Roads Act. You cannot amend that act unilaterally through the National Assembly. It must go through the Senate. You have got Section 76 of the bill, which proposes to amend the Employment Act, and by extension the Housing Act. All these acts require input from the Senate. One house cannot amend them. So I'm saying that those particular provisions cannot be allowed to stand in the finance bill today, and they should be kicked out. Then you've got Section 76, 78, and 79 of the bill, which concern what should be in a finance bill. And that is defined in Article 114 of the Constitution. So you'll find that in this current bill, finance bill, has got so many things that are not money matters. There are things affecting other things. And those things cannot be allowed to stand in the finance bill, because the finance bill is supposed to address only money matters. And it's clearly stated in the Constitution. So Section 76, 78, and 79 of the bill violate that provision. So, and if you look at it, generally, collectively, these violations violate also the Bill of Rights, and have not invoked Article 24, which allows them to limit the rights. So as you go on, you will find that there is also, the Constitution also prescribes how Parliament should behave. It prescribes how the Executive should behave. It prescribes how the Cabinet Minister should behave. And when they do things like this, we really find that they are violating those provisions of the Constitutions, which are express provisions. So, as we go ahead, and then outside the Constitution, we have got natural law, which requires certain things to be done in a certain way. Either it's just or it's unjust. So, when you come to this section, you'll find that about 60% of the budget that we are trying to finance through the 3.6 trillion budget we are trying to finance through this finance bill is paying debts, foreign debts. The government has totally refused to have the debt register audited. People believe that the debt that has been declared of 8.7 trillion is fictitious. The correct debt is supposed to be fictitious to the extent that that money was never used to serve Kenyans. It's an odious debt. So there's need for this debt register to be audited to remove debts that did not come through the correct way. We have very many debts that were never approved by Parliament as required by law, were just made by people who are in power. That money remained out there. You saw the Panama Papers. That's where this kind of money goes. They hide them offshore, and then they're bringing that money for Kenyans to pay. So the issue is that we cannot continue paying debts that we don't know what they did. You have things like Kenyan Fertilizer of 1974 in Dagoretti. We don't see that fertilizer factory. We are paying those kind of debts, and there are very many debts of that kind. So why are Kenyans being forced to pay debts that did not benefit them? It's a moral issue, and one that we must sit down and say, okay, we are reaching a point where we must audit these debts. So even the moral foundation of the finance bill is not there, because they are paying 60% of it is going to pay debts which have not been audited, debts which have not been declared. And so we have got all those things that are of concern. And so I made an offer that it be relooked at, but I was answered that it cannot be relooked at. So the only option there is to go to court, and I've gone to court. And I hope that I will get justice. So I'm prepared to argue my case, and it's already been filed. So if there's any question, the amount is about 8.7. But some audits that have been done by some experts put them at around 4 trillion. So there's a difference of about 3.7 trillion that have not been explained in debts. So we must open up these debts and know what are we paying for. We cannot be taking money from poor people to go and pay off money that was stashed abroad. So that's the next frontier is going to be a difficult fight over the debt, because we are not going to be paying debts that we don't know, and that has to stop. So the debt register from 1963 to today must be audited to ferret out odious debts, and if there are debts that were taken by individuals, let those individuals pay. Or we pay, then we auction those individuals, because most of these people who have been senior civil servants, who have been senior politicians in this country, are extremely rich. We hardly have rich entrepreneurs here. Wealth has been made through public service. So public funds have been privatized. And if you saw the amount of money that were declared in the Panama Papers, none of these people worked abroad for them to have earned money outside to be keeping them out there. So these are the debts they borrow outside, and instead of the money coming here to do development, they divert it into private accounts, offshore accounts. So for me, we cannot just be taxing people and saying we have to pay debts, you have to do whatever. Let us audit the debts and reject those debts that did not benefit us. Only pay the debts that benefited us. Thank you.
Senator, we have an Attorney General that we pay dearly to save us from...
You need a very sharp judge.
No. It's you who has always argued that a judge is as good as your arguments.
Yes, there is that, but there has been another dimension that's emerging of late.
Which is?
Police the executive, or trying to police the executive.
Is that from bottom to the Supreme Court? Is it also?
Yeah, it is beginning to. There's a thread running through. That's beginning.
This in vain?
No, it's not in. I'm not acting in vain. Officially, you land before a brilliant judge or a courageous judge. All of them are brilliant. You get a courageous judge, and you will earn your sweat. But sometimes you don't. But anyway, there's a filter, so we'll be able to go through. So I'm just saying that there's also a degeneration in the judiciary. We are going back to the old habits, and some of the very strong judges have deliberately been moved out of Nairobi. So those kind of things have happened, but we don't give up.
Have you complained to the JSC?
We don't give up. So nitawatumia nini kwa soft copy. I hope you are not on my mailing list.
Please, to me,